It's a Monday. Welcome to PM Express. And I have a guest tonight. You only see him in court. There have been a few cases, high-profile ones, broadcast live, and there you may have spotted him. Yes, in the background is the man, Thaddeus Sorry. He is my guest tonight. Rarely would you use the word exclusive when describing an interview, and you will be absolutely spot on. This one is absolutely spot on. You rarely speak to him in the press because I know him. And anytime I've called him on anything, especially when the case is pending, you will not hear him talk about it. He's here only because a lot of the cases that he's been handling are not the subject of conversation. All of them have been decided, and so he's free to talk about them. But we'll talk not only about cases, we'll talk about democracy. We'll talk about jurisprudence. We'll talk about the Constitution. And as you know, the judiciary itself has gone through a very trying time. Where is the judiciary as we speak currently, and what will it take for it to restore its credibility, its legitimacy in the eyes of the citizens? I'll pick his thoughts on that. He has been the lawyer involved in many high-profile cases. A few of them, he was involved somehow as one of the lawyers in the Chief Justice's removal process, and so he has first-hand knowledge of this. But we'll also need to test and interrogate his thoughts on the Article 146 procedure there, because there is, I believe, consensus on one thing, that we need to do something about the procedure. Does he belong to that school of thought? The former Chief Justice, Sophia Kufu, had made her case. Others, in fact, Mahama Yarga on the floor says part of the constitutional review process that is currently ongoing, we'll see some reforms being suggested on that front. Well, what is his own thoughts on that? I'll ask him that when we sit for a conversation. And then we have one of the big cases that he was involved in, that case about Parliament's vacancies that were declared. It was very controversial shortly before the 2024 elections. He was involved in that. Also had significant, I guess, points in there that also points us to the need for some reforms. I don't know what his thoughts are and what the court decided, and the views that were expressed at the time by the man he represented, who happens to be the Speaker of Parliament, who believed that the court was parked at some point. He was vehemently opposed and disagreeing with the judgment of the court. He respected it nonetheless, but he did not hold back in describing how he felt about that judgment. I'll ask his thoughts on that. And then legal independence, the judicial independence, the GBA's credibility has been called into question, so much so that there is a different group now negotiating and making the case for it to be granted a license so they break away from the monopoly of the Ghana Bar Association. Where does he stand on that? I'll ask him on his thoughts on that too, because he also has written a fair bit about the GBA itself. I'll put a few of his own quotes to him. He is very prolific when it comes to writing his opinions on matters, and so there's so much to find to hold him to. And I'm going to try and do that because I love reading his thoughts. I can decide not to go to law school and just spend my time on his wall on Facebook, and I think I'll be fine. And that's how good he is. And I'm going to hold him to a few of the things. That's him there. That's the man. Thaddeus Sorry, in all his glory, seated right here with me for a conversation. Stay with me. After this break, we'll be talking to him here on PM Express. And thank you very much for staying with us here on PM Express. It's always brought to you by Syntex Tanks. It is strong, it is tough. Academic Times and Pepsodent Cavity Fighter Toothpaste. Ghana, let's talk water tanks. Do you know the secret to real water storage? It's simple. If your tank doesn't have the tortoise on it, then it is not the correct tank. That's right, the tortoise tank, Syntex Tanks, is the champion of water tanks. It is strong, durable, and built to handle our Ghanaian weather, rain or shine. Syntex Tanks has your back. Syntex Tanks are strong, they are tough. And then the Academic Times, it's a journal. It's launching soon with 3 distinctive graphic publications and a journal to showcase and empower students across all educational levels, while the journal and the tertiary G seeks to ensure that tertiary students' research makes an impact. And finally, before you sleep tonight, make sure you use the Pepsodent Cavity Fighter, because that is how you protect your teeth and your mouth from gum disease and, in some cases, foul breath. Brushing your teeth every morning and night with Pepsodent Cavity Fighter gives your teeth the protection they need, leaving you with 10 times stronger teeth. Pepsodent, every smile matters. My guest tonight on PM Express is Thaddeus Sorry. He is a lawyer, and he has been involved in quite a lot. And so I was digging into him a bit, and I realized that he's also, apart from all the serious stuff that he does, and you've seen him in court, and you wonder whether he even has a life. He indeed has a life. One life that he has is supporting Liverpool. And if you know anything about me, I'm a die-hard Manchester United fan, and I couldn't start anywhere else. And this is the day after the afternoon before when we walloped Liverpool at Anfield. The first time it's happened in a long, long time, and he somehow chose to be on my show on this evening. So I have to start there. Thank you very much for joining us on PM Express.
Thank you, Ivan.
And better luck next time.
Well, that's football. Sometimes you're lucky, sometimes you're not lucky. And I'm sure you remember as a Manchester United fan that not too long ago, you were well up 7-0 in a one-sided
I do.
Against a team that didn't look like a Manchester United team.
And you helped us sack our coach.
Yeah. In fact, that's not the first time.
True.
I was also at Anfield when we beat you 3-1 or so when Mourinho was there, and right after Mourinho was sacked.
Yes.
So just, I mean, in a scrappy game that you laid back.
So having said that,
that's fine.
This is, for the first time too, Liverpool is going to help us launch the career of our coach. So we are going the opposite direction now.
That's quite hopeful.
It's actually the reality.
I say it's hopeful, but that's fine.
And it's also going to start the utter collapse of Liverpool. Because when you lose at Anfield, the hands of
another bad
the back of four defeats.
Another bad prayer that God won't answer, but it's fine.
Oh, God has answered already because it's happened yesterday at Anfield, by the way. So you know he's not just a man in court who is making all these wild, legal, mind-numbing cases, but he's a man who also enjoys football. But I'm grateful that you decided to join us. Let's talk about your legal career. And I'm fascinated by it because a decade ago, I used to talk to you quite a lot, but there's something about the ethics of the profession that always stood out when I've spoken to you recently. No matter how passionate you feel about a subject, when people had called you a lot of names and said things on my show and I've called you, you still told me you're not going to speak to it because your case is pending at the court. When everybody else was speaking on the matter, you held your peace. Where do you find that calmness to still remain ethical? Because you told me you just simply don't want to do it because it's not ethical. Well, where do you get that from?
Well, it's based on my upbringing, one. Two, I also relate with people who believe in standards. And so if you find that I'm committed to a particular principle that I say I won't violate, it's because I believe in standards. And so even at the level where you are dealing with ethics of your profession, you are taught that right from the time when you start growing up, that in a society you need to respect standards. You need to respect principles that people subscribe to. And so if the ethics in my profession say, do not speak about a matter when it is pending in court, especially when you are conducting it, because as a lawyer, your duty is to conduct your case in the courtroom, not in the court of public opinion. There's no reason why I should depart from it, only because people want to upset you or to get under your skin or to provoke you to do what they know you shouldn't do. You should remain focused. And that's what's important.
It's interesting you say that. I wondered then, because you were involved in possibly one of the most consequential cases in the Fourth Republic, at least the outcome says that is led to the removal of a serving Chief Justice in the Fourth Republic. It has been attempted before, it hasn't succeeded in the Fourth Republic. This succeeded, so it's very consequential. So you say that, and then you see the press conference that was done by the then suspended Chief Justice regarding a process that's supposed to be in camera. And I wonder what your reaction was, considering what you just said about your own personal beliefs about ethics and keeping to the rules. And then you see her do a press conference about a case that you were involved in.
But I'm not sure you recall, because I reacted almost 30 minutes right after she did.
She did it.
Because I thought if a serving Chief Justice should descend that low, she's not just a Chief Justice. She's a lawyer of so many years' experience. She served on the bench for over 20 years. She should not be the one setting that bad example. And I had to do that to correct that point. Secondly, she put out there deliberate falsehoods that the public needed to know about. And as a professional, there are two things I owe the public. I mean, I have a duty to the public as a lawyer. There are fourfold duties of a lawyer. One of them includes serving the public. If I realize that a lawyer serving Chief Justice at the time and a judge of so many years' experience has gone out to mislead the public, I owe it as a duty to the public to let them know exactly what the truth is. And so 30 minutes right afterwards, on my Facebook wall, I corrected every falsehood that she put out there to the public, both in law and in fact. So that is why I did that. And under that situation, in that situation, I had to weigh between my duty to the public and my ethical commitments to the profession to uphold the general rule of practice that we do not comment on cases that are before or that we are conducting or that are pending. So that's why I did it. I actually commented on that occasion. I violated the rule, but in another context, I didn't, because I also owed the public the responsibility to ensure that they knew exactly what was going on.
But in doing so, though, weren't you just repeating the mistake that you're criticizing?
But I just explained to you
that they
were competing.
There's a public interest there.
Yes, and where the public interest is at stake, the public interest trumps every other rule that would be under consideration. So I owed the public that duty, and I don't regret that I did that.
And I wonder, because you now raise the issue, of course, this is one of the things that you can expect will dominate the conversation with you, because one, it's consequential, two, you were involved in it. But since you touched on that, and I wonder when I first heard it, that this could be a further case against her before the committee, because the committee was still in session.
Yes.
The committee was still seized with the matters he was talking about.
Absolutely.
Did he ever come up, her press conference?
No. The committee didn't talk about it.
And you didn't raise it too?
We never raised it. For several reasons. One, we were before the committee and focused on allegations made against her. Those were distractions. In fact, case law has settled what the options are when she does that. It is not before the committee. And so those were not matters we intended to distract ourselves with before the committee. So we decided that, look, let's proceed with the case and allow her to do whatever she wanted to do. If it becomes necessary to deploy the other options that were available to deal with that, with her conduct, then we'll deal with it.
Which options were those?
Oh, there are so many. There's a Justice Brennan decision in the Tiger PI matter, in which he says, look, among them is the option of contempt of court.
Yeah.
And so we could have deployed all of that, but
wouldn't it be contempt of the committee?
Yes,
because it's the constitutional committee?
Yes, of the committee, of course. So we could have done all of that, but we didn't want to look like we were getting personal. We had an issue, we wanted interrogated, and that was what we focused on.
Okay. So never came up. The committee itself never brought it up?
Oh, not at all.
They didn't take notice of it at all?
They may have taken notice of it, but never raised it.
Okay.
There were even instances that certain things happened before the committee. She conducted herself in the most reprehensible
Before the committee?
Before the committee, but we all decided not to talk about it. And there were instances when she had to apologize, or her lawyer had to do it.
On her behalf?
On her behalf. In fact, there was a time when her lawyer turned and to try and speak to her, and didn't even know that she had stormed out of the committee's proceedings because she didn't like a ruling delivered by the committee.
So she walked out on the committee?
It wasn't once. So these were things that it wasn't necessary to, and I was surprised that she was one of those wanting these proceedings to be public. Yeah. If the public had seen some of these things, I'm not sure they would have been happy with it. You know?
But that call, did you support it? The call to make it public?
It was plainly unconstitutional. And you wonder again how that person was in the court that interpreted our constitution, which spoke in plain language. You are entitled to insist on a reform. But once that reform has not occurred, you should show the public the clear example of following what the law says it should be. And so the law says it should be in camera. And the in camera even starts from the time when the petition is submitted for the removal of either of a justice or of the Chief Justice. And that you don't violate it right from that time. And so how can you be insisting that even the committee's proceedings, which the Constitution says must be in camera, should be made public because it is just you. Should it be done for everybody or just you? And so these are things that didn't even sell her very well to the public because it showed a person who thought she was different from the people she was, appointed to serve.
You made the point about her disrespecting the committee during the committee sittings.
Yes.
Is it just because he walked away or because of...
I don't want to go into it, but even going out there to make a public statement and literally indict the committee based on facts that were completely untrue, saying, oh, they were applying rules that didn't exist, they were opaque, and all of that was plainly false. Right from the first day, the committee indicated its procedure. And it's interesting. There's a June 2020 case, in a case involving a previous justice of the Superior Court, I think it's Justice Essel also, in which Doche made a call on the Rules of Court Committee to enact rules for Article 146 proceedings. She became Chief Justice during that period. She spent her time making rules that were plainly unconstitutional and forgot Article 146. In any event, there is nothing wrong with Article 146. It's not just once, or this is not the first time I've been involved in Article 146 proceedings. In the Opong and Attorney General matter, which was about the first case brought under Article 146, I was a very junior lawyer involved in it together with Ambrose Derry and Samuel Kujo and co. It was followed. And nobody raised issues about due process and all of that. Before the proceedings start, you are told and you are engaged about the procedure that will be adopted. I was involved directly as counsel, lead counsel in Charlotte Osei's matter. We were told what the procedures were. There were plain violations that were even recently now admitted of Charlotte Osei's rights. And nobody said anything. In fact, the person who was Chief Justice at the time came to testify for the present Chief Justice. In fact, she wrote a decision in which she admitted that the committee of the kind before which the Chief Justice appeared is ad hoc in nature and that they can determine their own proceedings.
I talk about Sofa Akufu?
Yes.
And this is what Sofa Akufu says. And this is her verdict on the outcome of the Article 146 proceedings against Tokono. Quote, she did not get a fair trial. Even though it is not a trial, strictly speaking, it was handled as though it was a treason trial.
Yeah.
What's your response?
So these are mere words. And let me make one acknowledge. I'll acknowledge one thing to you. Sofa Akufu is my mother in practice, godmother in practice. Okay. That the first day she saw me, I was very young at the bar. I won't tell you here for some reason. She called me into a chamber to say, look, a young man, for how long have you been practicing? Let's not go there. So she's my mother in practice, and I acknowledge her. At this point, she's speaking like anybody. It holds no weight. And she says it was handled like a treason trial. How is a treason trial handled? By a number of judges. Is that what she saw there? No. There were clear-cut rules we were all supposed to obey, and we were all engaged.
Just the trial wasn't fair.
Why was it unfair? If you say it's unfair, tell us why it was unfair. Is it that she wasn't served with any processes, she was not allowed to use her lawyers, or things were done ex parte? No. She sat there. We called our witnesses, her own employees. They came and testified regarding what she did. A registrar from Kaswa, I'm saying that the Chief Justice of the Republic of Ghana is so concerned about matters as low as matters pending before a district court in Kaswa. Said that she can call the registrar and tell the registrar that, look, a step you have taken to execute the judgment of the court should be reversed. And the Chief Justice answers by saying she doesn't even remember. The sad thing is that this Chief Justice has been told the suit number. She's been told the court in which it occurred. She's been told the title of the case. Couldn't she just have called to find out what case is this? Because I'm alleged to have interfered in it. At what point in time did I? She said she doesn't remember. even when she entered the witness box and the registrar came to testify, to say, I appeared before you, and these were the interactions we had. In fact, there was a gentleman called Bannerman who was involved in the proceedings. I don't know where he is now. She entered the box and said, oh yes, I even found the Bannerman. But the Bannerman said that he doesn't remember. Why didn't you just bring Bannerman to come and testify? So these were things that were, I mean, when somebody says, oh, they were opaque trials, in the course of those proceedings, now that this, it is over, if push gets to shove, we will publish some of those proceedings in order for you to see how it cannot be true for anybody to say it was not fair, because the Chief Justice herself on oath said the committee had been very indulgent of her. And let me tell you that.
As in the Chief Justice who just been removed.
Oh yes, she testified on oath that she must confess they've been very indulgent. After you tell the public that they were very indulgent of her. It is recorded. In fact, I made it a subject of my comment in my address, final address to the committee. So we don't want to talk about these things. So she served the country as Chief Justice, whether we were happy with it or not.
But she told us, the public, that, first of all, as far as the fairness of the trial is concerned, of the hearings are concerned, that in one case, some of her gadgets were not allowed in. Her lawyers, were inhibited compared to other lawyers like yourselves. So, you listen to that. And that all borders down to, one, either she was being intimidated, so that, of course, she loses her composure, and her and the lawyers. She creates impression and speaks and articulates views about a process that was deliberately crafted to disadvantage her. And I guess it's possibly what Sopeko was picking up on when she says it was not a fair trial.
So this has nothing to do with the trial. But first of all, apart from just saying, okay, your lawyers were not allowed to use their gadgets and all of that, these were conversations we all had.
You agreed?
Oh, because when the committee started, we needed to let them understand that, look, we needed our gadgets. And we had a team whose role, and we divided our roles. Everybody had a specific thing to do. There's an interview that I don't want to refer to. Somebody said I was writing profusely when the proceedings were going on. I couldn't tell what I was writing, but I was worried that I was writing. That too almost would amount to a violation. But let me go back a little bit. What they talked about affected all of us. We were all screened. There was a lady on my team who was screened as she went in. And what she calls a search, it's not true. It's that thing that they will place on you. There was a lady specifically assigned to screen ladies. So no man searched her, or she wasn't subjected to anything that no other person was subjected to. Her lawyers were subjected to the same thing that we were subjected to. So in the course of the proceedings, I said that, look, I need to use my gadgets. And everybody who knows me knows that when I enter the courtroom or wherever I am, I use those gadgets. So as my senior, Mr. Chachuchikata, is cross-examining, I'm busy taking notes because every lawyer knows that even in the course of court proceedings, sometimes you're not allowed too much time to decide when you want to file your addresses. They had 4 lawyers just like us. Nobody was doing that. I was doing it. If we were able to file our address within time, it's because we weren't taking chances. And we didn't even like the time that they gave us, because if I had enough time to write that address, it would have been a much better address than what I put in. I didn't see them writing anything. So any of them could have written. Any of them could have done anything that they wanted to do. Nobody restricted anything. You just heard all of this they are saying. They are all show us how it violated your right to a fair hearing under Article 19. That is all you should show. That you were given facilities to represent yourself. You are allowed to come in with your lawyers. Adjournments you took. When we were conducting our case, the pressure that the committee put on us, we still accepted. And we tried our best to do it according to the committee's...
You've heard a lawyer say, and this is Ayuko to say, that even in filing the address, at the time they're ready to file, that morning, is when they had the decision of the president.
Yeah, I've heard him say that. You see, I never wanted to comment on anything that Ayiko said, but you are not a lawyer. The committee gives you a date to file and gives us the same date to file. We managed to file on that date. The committee gave rendered its report, I think, a week after. So between the time that you said, the committee said for us to file and the time that it rendered its decision, you did not file yours. So the committee should be sitting and waiting for your sweet time to decide when you want to file? Or did you have an agreement with them that they should not present their reports, but wait for you to file? So I don't understand all of this point. There's a dead time, set time for you to file. You didn't file. The committee did not give you any assurance that they will be waiting for you. Did you tell them that you'll be filing on that Monday? He doesn't say that. He said he filed when he wanted to file or when he was ready to file. But it doesn't happen anywhere, even in regular proceedings in the courtroom. If the court says it's time, you must obey. The Chief Justice knows that. And what in your intro when you were talking about the Speaker's case,
yeah,
was the Speaker giving that such latitude and luxury? He wasn't even served. He had an injunction slapped against him pending the final determination of the matter in an ex-parte situation. How is that person now complaining about injustice and lack of fairness and all of that?
Well, she was a Chief Justice of the
Oh, yes. So when you are Chief Justice, you are entitled to do what you like. When you are given a taste of the right medicine, you gave the wrong medicine and somebody took it. When you are given a taste of your own medicine, then it's unfairness.
But apart from Sophia Kufu, there were others who also thought the process was flawed. The Ghana Bar Association, of which you are a member.
Oh, proud member.
Of which you're a proud member.
Yes.
Said that the acting Chief Justice should withdraw his directive. This is the time when Bafo Boni was acting.
Yes.
On assignment of case, the president should revoke the suspension of the Chief Justice. You quickly wrote on Facebook,
yeah,
quote, and this is your title, revoke and suspend the bar. Did you mean it literally, though?
Oh, of course, we're right.
No, okay.
So I mean, you can't revoke and suspend the bar.
Yeah, but you're saying that these demands are not only legally flawed and disrespectful, but they also expose a troubling inconsistency in the bar's reasoning. There is no need for threats and rhetorical outreach. You actually tell them to go to court if you may. You're not so.
But we are lawyers. Why do we feel comfortable? Where is our playground? When I got in here, I was nervous. Because this is not my playground.
You were nervous because I was going to raise Manchester United beating Liverpool. Not because of the interview.
It's okay, because I've never been in a studio like this. It's my first time.
That's true.
But my natural home is the courtroom. Why are you threatening the president? It's not as if you haven't gone to court before. The Ghana Bar Association has gone to court over the most frivolous cases. There's one involving the former Chief Justice, Justice Aban.
Yeah, Justice Aban.
Who wrote...
Who also went through the same process.
Yeah, no, he didn't go through Article 146. The Ghana Bar actually went straight to court to say that because he wrote a judgment in which he misquoted or misrepresented a speech given by Buzia, he was not a person of high moral character and proven integrity. So he should be removed from office. At a time when he went through Parliament, which represents the whole of Ghana, and Parliament had decided that, notwithstanding that error, he was a man of high moral character and proven integrity. The Ghana Bar Association said, no, we don't agree that he's of high moral character and proven integrity. They went to court. Why are you now sitting here? You can't point at one breach. All you do is to say, there's a breach. The process and due process. And that's all they say. Say, according to the rule, you should pass through these processes. A, B, C, D. A was missed. C was not applied. D didn't even exist. You can't point at one. And all you are doing is doing cases in the media where you shouldn't be doing your case. That's all I was telling them, that look, clearly you have no case. You even you've taken other people to court before. I mean, on similar instances. Why are you doing this one in the media? And as a member of the bar, I owe it a duty to that bar and myself to tell them that, with all due respect, I didn't expect that to come from the bar. a layman from my that I come from the same village with, I said that sometimes when the bar speaks, even laymen don't understand what they are saying because they can read it in black and white. So as long as I remain a member of the bar, if I don't agree with things that they say, I've represented the bar before, you know that. Yeah. There's a famous case that they keep touting. Ghana Bar Association versus Attorney General, and that one had laid down principles for the appointment of judges. They should go and check who their lawyer was. I was their lawyer.
Are you still a fan of the Bar Association?
A very big fan.
Okay. I asked that question because recently,
yes,
there's another group that is seeking to break away.
Are they breaking away, or they have a right to start?
The Ghana Law Society. You believe they have a right to?
It is in the Constitution. We all have. There's freedom of association. If the people, I think the Ghana Bar should even support them to stand alone. If there are several lawyers, lawyer groups in this country, and we all unite to fight a cause, whatever cause we are fighting, we don't even need to speak. You will act. So I think they are not breaking away from anybody.
They are, though.
Why are they breaking away? They are only deciding that, look.
If they have their way, you only have the Ghana Bar Association, you have the Ghana Law Society, that will be members who used to be members of the Bar Association, who no longer belong to the Bar, will belong to the Ghana Law Society. If
we all had our way, we would all be NDC members or NPP members or United Party members. But our society says, for the purposes of our democracy, we should have diverse situations working together to achieve a common high standard of democracy and constitutionalism that we all aspire to. And so I'm saying that if anybody wants to have what we had a Bar Association of Ghana, but is that type of thinking that made people not want to associate with the Bar Association of Ghana. The Law Society are lawyers just like us. And the Ghana Bar should be proud that there are some people who are conscious enough to want to be members of a bar, but not a member of the of an association of lawyers that they belong to. So I don't think there's anything wrong with it.
If that is formed,
yes,
would you still stay with the Bar Association or the Ghana Law Society?
I have a choice. If I don't feel that the Ghana Bar Association shares my views or doesn't represent me, and I have complained about that before, that some of the positions the Ghana Bar has taken is disgraceful, because as a member of the bar, I have faced the most adverse circumstances publicly. Even people who don't know anything about the law have said, no, but this cannot be right. The Ghana Bar Association was quiet, and I'm your member. And I still feel that I'm a member. But if we have options like that, and I feel that, well, Ghana Bar Association doesn't think I'm their member because I can't suffer that, and you don't even send me a message of solidarity. You are against an institution that showed clear-cut oppression in a forum where I should never feel oppressed. Because when I walk into a courtroom, I should walk there arrogantly, excuse my language, for want of a better word, because that is where I should feel safe to speak my mind and speak the law. But I get in there, people, the people who are supposed to protect my right to speak, because as a lawyer, when I get up and I'm going to the court, I go there to speak. It's not the judges who should be speaking. I go there to speak. I prepare to go there to speak to the judges. And the judges say, no, you can't even speak. Every time I want to speak, say, no, wait, I want to ask this. Before I answer, no, there another question comes. Listen to what I'm saying. That doesn't happen anywhere. Even in the Chief's Palace, they listen. So, and the Ghana Bar Association doesn't see anything wrong with that. When I was growing up as a young practitioner, Peter Alajete and co, they would stand right in the courtroom, you would have risen. They said, no, what is happening here? It's not a courtroom. So the Ghana Bar Association couldn't have seen that, kept quiet, and they are saying, oh no, but the Chief Justice's rights have been violated. And you can't even point at one. So you are becoming partisan. And that's the reason I would criticize them.
So, and I was coming to that question because recently at the conference, whether it happened in your home region.
Yes.
Were you there?
I wasn't there.
You were in there. The Attorney General made the point.
Yes.
Actually suggested and criticized the bar about partisanship.
Yes.
You agree?
I agree completely with the Attorney General. And the Attorney General, I respect him for doing that at that forum. If he had said that somewhere, I would have been, I wouldn't have respected the speech. But he said it to the bar in front of everybody at the bar. He got an applause.
Give me the evidence that backs your claim that this bar association is partisan.
It's not this bar as I don't want.
Oh, the bar association.
The bar association.
Okay.
And
give
I'm
me
saying
evidence.
that.
What's
I've given you so many examples.
In your case, but that they didn't come to solidarize. Doesn't mean that they are partisan.
So there's what we call evidence. I can speak to what I know.
Tell me, what do you know?
And I'm saying, and I can only speak to what affects me directly. In what affects your own member, you are silent.
But you're not a partisan animal, are you?
No.
You're a lawyer.
No. So if they are then supporting a person who has an association, the Chief Justice has the Association of Judges and Magistrates, where she belongs as a member. They didn't even issue a statement, and they are judges, and they didn't see any violation of due process. It is my association that saw it. And my association couldn't even point at one thing that was wrong. Up to date, they can't do it. You have just read what I wrote to them. Go to court. Why don't they have the boldness to even take up one of the...
Maybe define for me, when you say they're partisan, what do you mean?
That they have an interest in, I mean, from what they have shown so far, they have an interest in the Chief Justice. It's not in the delivery of justice.
They have an interest in the Chief Justice, they have an interest in the MPP, to put it bluntly.
By extension.
Okay.
By extension. Because for a very long time, and the Attorney General pointed that out, it may not be directly, I mean, it may not be proven beyond reasonable doubts, but we all can reason. If over a long period of time, we can tell, I mean, there's violence in election matters at Ayawaso, at Ejura, and all of those places, people have lost their lives, and the bar can't even say, this is unfortunate. In fact, they can't even say that, well, we don't know who is responsible for it, but can steps be taken to know who the perpetrators are so they can be dealt with? The bar doesn't say anything about it. In this matter that I consider completely something that didn't warrant their intervention, they are on the high...
but the bar tell us that,
yes.
They tell us that there was a resolution at one
mini conference of 47 people.
Of 47 people.
When at the last conference, we had about 1,000 people being called.
Yeah, but a resolution nonetheless.
I mean, let's be all due. And the resolution was so empty and hollow. But there was nothing in it. They couldn't point out, what are you doing with resolutions? Me, I'm a lawyer. If I find anything wrong, I will go to court and challenge it. I won't be talking, even it's your duty to be doing radio and talking plenty on radio. For me as a lawyer, the test that I believe in what I'm saying is in the courtroom. And so when they reduce themselves to public, I heard somebody say I was a public commentator when I don't really speak on public issues. If they reduce themselves to commentators on public affairs or matters that people are commenting on, it devalues our profession. That's the reason why I criticize my association. But I'm nevertheless the proud member of the association, and I will always support the association.
And you say that you actually haven't said categorically that if the Ghana Law Society is formed, you will still stay with GB. You actually told me.
No, I'll stay with the GB.
But you say you will consider depending on...
No, I said if at any point in time I feel...
Yeah, you have an option to move.
Yes, and that is the reason why I would encourage them to be there, because they are there for my interest. That once they are there, if the Ghana Bar Association continues to make me feel that I'm not important in their scheme of affairs, it only means I can go the other way.
Is it the Bar Association or its leadership?
Over the period, the Ghana Bar Association has shown a particular tendency, and I could identify and agree with the Attorney General with regard to his observation.
I mean, any follower of the way the Bar Association has conducted itself, remember that it came to a peak when Neil Samuels...
Great point.
Neil Samuels, and that was when it played out very openly. There was accusation. He left eventually. I mean, he was
forced out.
He was ousted. Yes.
He was forced out.
He was ousted, and everybody thought it came to a head at the time when something needed to happen to reform the Bar Association. Why didn't that happen?
I want to take you back.
Was it not?
Evans, why was Neil Samuels forced out? Because he had gone and visited a member of the bar who was in prison. And the bar took a position against the president of an association who had gone to visit a member of the association who was in prison.
Well, he was a convict at the time.
But so he sees this to be, why do we have unions and associations and groups? That at least welfare is what the union should care about as far as their members are concerned. The man had an appeal pending. And this was not any lawyer. This was one of our celebrated lawyers. So if the bar president just goes to visit his member who is in prison and he's convicted, he's in prison because he's been convicted, what is so heinous about it that he should be forced to resign?
How can the bar present itself differently? Because you perceive it to be partisan. You perceive it to be MPP aligned, to be put it bluntly.
It's my perception,
yes,
because of the way things have gone.
How can the bar reform? And I cite Neil Samuels just to make
that
this is not the first time this accusation has been made against the bar. And it still persists.
I've seen one or two people aspiring to leadership positions, I wouldn't mention names, who may show stronger signs of better judgment than what we see now. And so, look at it. Some of the examples I would give you would be too graphic, and so I don't need to do that. So you find the leadership aligned to obvious politicians, and it doesn't give a good impression, especially when the thinking and the action is linear, and it seems to support a particular political orientation. It doesn't give a good impression.
Let me put to you something that your good friend Godfrey Dami said about
about me?
Yes. And this is on May 21st. And it comes to the issue of partisanship and politics. Yes. It says, quote, if there are any, and this is the Chief Justice's removal process, if there are any group of people who have politicized this process, it is the NDC government. Look at the band of lawyers representing the petitioners. Mr. Chachu Chikata, Mr. Tadio Sori, a lawyer who has gone on record as representing all NDC figures in the past 8 years, and who is very much associated with the NDC. Are you NDC?
That is strange. And I want to wind back. I think you know Justice Joni Kulendi, who was in private practice. We were very close when he was in private practice.
You come to the same region?
At that time, you wouldn't see him in court without seeing me, and we're practicing from different offices. He did Ghana at 50. Call him right now and ask him the role I played in Ghana at 50. The current Attorney General was my big boy in secondary school, and in fact, he mentored me up to law school and beyond. I accused him when the NDC was in power that the NDC targeted me. Obi Amwa, I slept at police headquarters with him. Are those NDC members? So I'm surprised. To be honest with you, I sell my services as a lawyer. If anybody comes to me and I feel comfortable to defend you, I would have been involved in some of the recent cases. It was because of the way some of the cases were politicized. So if I took your case, for instance, and started studying it, and I got a call from the minority leader, oh, you know, Evans is one of our friends, and I'm not saying that happened. But if he called me right now and said, oh, Evans is our man, so I'll hand you your brief. Because what is a minority leader calling me because you are a man? We are looking at the merits of a case. Let me do my case, you can do your politics. So I have represented people from on the MPP side very strongly.
But recently, though, well, it appears that almost all of your cases are NDC aligned. I mean, recently, I'm just emphasis there, Speaker of Parliament.
Yes.
Then you have this case that has led to the removal of the Chief Justice. Daniel Fori was your client. And as you said, because he was interested in removing the Chief Justice, you also said that the Bar Association had an interest in her, by extension, the MPP. So then the reason goes that the justification is that then anybody else who's removing her too must also be NDC. You see why they say that you are NDC?
Let me tell you, the Speaker I know the Speaker very closely. We come from the same place. 1. 2, I am a lawyer who gives my all to cases that I conduct. I have represented a lot of these statutory institutions from SRAJ, NCC, Electoral Commission, a lot of these institutions. So I have sufficient experience in handling those matters. So the Speaker's office got in touch with me to represent them. And the Speaker, where he sits, he's told Ghanaians time without number that he's Speaker for this country and not Speaker for the NDC. So I went there to represent an institution. I didn't go there to do politics. It is when I got into the matter, some of my interactions with the CJ herself exposed her as being partisan. When she said, oh, Parliament is not sitting. Meanwhile, the reliefs we saw before the court had nothing to do with Parliament sitting or otherwise. Parliament was still free to sit. So with what mentality was she asking those questions? That you can even make orders that are unprecedented in any framework of our legal principles. So what has that got to do with my being partisan? This Danofori's case you're talking about, I'm saying I take Danofori's case in 2008. In 2018, the Supreme Court gave its final judgment in our favor. Whilst we're navigating from the High Court to the Supreme Court, the CJ was sitting in the High Court in circumstances under which she shouldn't even have given judgment against Danofori in a related matter. She gave judgment against Danofori. Past comments that were needless didn't even arise from the record, called Danofori a fraudster. Then this matter comes up in the Supreme Court. We win it. And all of a sudden, you show up as a judge in one of their numerous applications. The number of applications EcoBank filed in Danofori's matter, not only it was almost criminal for any court to have entertained them. She shows up and she starts making the same statements she was making of Danofori in the High Court. To the extent that Danofori said, look, my lawyers, what are you guys doing? This woman has had an issue and she takes a particular position. It's deeper than that, but I won't say those things. She takes a particular position against me. She calls me a fraudster when there's no basis for it. So we go back to the court and say, disqualify the woman, disqualify the CJ from continuing to sit. And the court actually agrees that she's shown a bias against Danofori. So right afterwards, she becomes Chief Justice. EcoBank has nerve, and I say nerve. I'm saying it without apology. I can defend it anyway. To go to the High Court, to tell the High Court that the High Court should set aside the Supreme Court judgment. Fortunately, we still have, there are a few honorable people. The High Court judge looked at the proceedings and we drew her attention to the fact that every point that is being raised before you in the High Court has been raised in the Supreme Court, and there has been clear and direct findings on the same point. Dismissed the case peremptorily. We didn't even need to go start, we didn't file issues on interim of trial. Execution became a problem. Before we started execution, nobody in the registry was willing to cooperate. What had changed? It was a new person at the helm. So you could find every administrator not willing to cooperate with Danofori. And her conduct was completely different. And I'm saying that apart from that, I had a personal encounter with her. And I'm saying I was practicing the Supreme Court 20 years before she got there. So I'm not now going to enter the Supreme Court and be taught protocols of the Supreme Court or its rules, especially in the most disrespectful manner from her. So I had seen her conduct unbecoming of a Chief Justice. So I had issues against her. Did I need a new government to tell me that I should fight her? Did Danofori need a new government to tell him that? This has nothing to do with NDC. So Godfrey Dami had his views. And I've worked with Godfrey Dami when he was in private practice in cases. Well, at that time, was he NDC?
The point you make about the Chief Justice, you have a personal issue with her.
When I say personal, I don't hate her, but it's a
personal vendetta.
Not vendetta, point of principle. I have practiced in that court over years. I am not now going to a court which has lowered the standards that I saw.
So you didn't like her as a person?
I didn't like her as a judge. If I see her outside, there have been several instances when she's acted like that, right from the High Court to when I met her in the Supreme Court. Right after the proceedings, when I meet her outside, it's romantic.
I mean, so is it coincidence? You didn't like her as a judge. You've always not liked her. I mean, you've confessed that. And is it coincidence that all of a sudden you are a lawyer for Daniel Fori, who then files a petition for her to remove, and successfully you achieved that?
I've given you the history. There was no coincidence. I have always been the man's lawyer. Yeah. And if the man was going to file...
So why didn't you file this case to remove her last year?
There were accumulation. There were over 31 allegations.
Yes. So
we were not going to remove a Chief Justice just by one allegation and file another allegation. We needed to put together a number of instances.
So you've always had an issue with her as a judge.
That is, she had it in the High Court, Court of Appeal,
yes,
Supreme Court. All of those things did not amount. I mean, I couldn't use that to impeach her as a Chief Justice, but her conduct as a Chief Justice. And I'm telling you that...
You could have triggered the process. 146, stated misbehavior,
yes,
incompetence.
Yes.
So you've always believed
yes,
she was incompetent.
Good.
You've always believed that there's ground for stated misbehavior.
Oh, absolutely.
Last year, when the MPP was in power, you
yes,
believed that.
Yes.
But you didn't file it then. You only waited for the NDC to come to power to file it. Why?
Okay, now I get your drift. But I'm saying in the High Court, just what was her influence? If I wasn't satisfied, I moved the next step, or there were other options I could take to neutralize her behavior. For a person who was now at the helm, and I'm saying that when at the time that when the MPP appointed her, I needed to put together a number of factors. So that couldn't be done within a year. And I'm saying that if the MPP had broken the 8, I would still have put it in.
Would you?
Oh, yes. I'm a person who is not afraid of losing cases. I will make my points. She will know that I have these allegations against her.
In all honesty, you didn't gather the facts waiting for the outcome of the elections to file it.
Not at all. And Daniel Fori himself, if you have an opportunity, I'll let him come here and you interview him. He is a strong believer in God. And he told me from the first day, that, look, this case, he will win it. He told me every day, he said, this matter, forget it. I will win it, and nothing is going to happen. So we always knew God was going to intervene one way or the other.
Intervene to remove her?
In our favor. If it involved her removal, fine.
So you believe her removal is an act of God?
Honestly, in my heart, I believe it and I'm saying that not just because I'm a Christian, but this was a discussion between me and Daniel Fori several times.
And you think God simply answered?
I'm saying that if you want, I can give you his number. If you call him and he picks up, he will confirm what I'm saying now.
Now, both of you said and agreed that God would intercede on your behalf by removing her.
We didn't agree. We just felt it, that at a point in time, things have their...
You are that religious?
I won't consider myself, but I believe in God.
Okay.
And I'm telling you that at a point in time, you can just feel that there's a level of atrocity God will correct. And
this was a correction?
I believe so.
To remove her?
I believe so. I'm saying that, I've said it several times, that the committee, if she's not happy with the committee, Daniel Fori and myself, are equally unhappy. We don't think the committee did the right job.
Why did you say that?
Look, the kind of allegations we had against her, we are surprised to now be hearing that they relied on 2 or 3 to remove her. Seriously, we proved too much. That nobody should ever use their official position in that way, especially to deprive ordinary people of justice. There are gray areas. We can forgive that. But in certain specific instances, you can do it. It becomes bad. For an individual like that, if you know him, Whitechapel, he ran a chain of stores and also employed many people as big as any other, as some of your corporate institutions that people tout around. But they brought him to his knees. And the second, or he was about to be brought to his knees because somebody was interfering with justice at a time when a court had given him victory.
And then this conversation, this thread started when I quoted Godfrey Dam, and I insist he's your good friend. But I need to ask you.
Oh, you don't need this. He's actually my good friend.
You quickly responded when he accuse you of being NDC, that let me say this clearly, stop the tantrums. The next knock may not be a gentle tap. It will land like a sledgehammer. What did you mean?
I think we've passed that stage with Godfred and so many things.
Have you made peace with him?
Oh, we haven't met, but mutual friends of ours have said, look, you know, maybe you guys think you are just entertaining the public, but it doesn't look good.
So the people mediated?
Not really a mediation. I have, you know, everybody has somebody they will respect. And some of them called me and said, look, it's okay. It's not necessary. Don't rise again.
Was he also engaged?
I don't know.
You don't know?
I don't know if he was engaged. But there were times when I've said good things about him. In fact, what he said was false. In fact, I don't know why he even said it, that, oh, they have a band of NDC lawyers. Did I take my law certificate from the NDC law school? I'm practicing my law. If you are not happy about it, if you are not happy with it, that's your problem.
Yeah.
But so that was completely nonsensical. But that's not something I want to respond to.
So your relationship, how would you describe your relationship with him now?
I haven't met him, right? For me, it's cordial. There's no engagement I'll have with you that I hold personal. In fact, beyond this place, when we live here, you have your friends you go to. I have my friends I'll go to. So if we have a disagreement here, I don't carry it beyond the studio. So I don't have a problem with Godfred. I mean, I've done cases with him. I think I granted an interview to KSM also, in which I commended him for something he did in court.
What?
There was a motion I was supposed to move for bail. I told him that if he's the Minister for Justice, I will move that application for bail. He has to move it. And in all candor, he got up and said, look, he would not oppose bail for my clients.
Who is this? What's this?
Collins Dowda.
Okay, Collins.
And that was an NDC man. Or that is an NDC man. So I commended him for it. So as long as I disagree with you, even if you're my friend, you should understand that it's on grounds of principle. As a person, what do I have to hate Godfred Dame for?
And Godfred Dame says, I live in your mind rent-free.
That was, I don't want to use that. He lives in my mind.
Rent-free.
Indeed. He's my junior one. Why would I...
That's he though.
Yeah?
Does he live in your mind rent-free?
God forbid that. Better things in my mind. I don't wake up to think about any lawyer, less him. Why would I be preoccupied with Godfred? Why? Because he was Attorney General.
He was, yes.
Of course. And there will be plenty after him. And long after we are gone, there will be plenty. There's nothing special about him. He said he had beaten me in a case that I don't remember. What shocked me was that, in fact, he had a raft of victories against me. He didn't mention any of them. The Speaker's case, who won it? Was it not him?
He did, yes.
Was it not him? Why did he mention that one?
On a more serious note, though, one of your, I don't know whether he's your client, Jakpa,
yes,
has taken a case to the police CID about that conversation that they had that leaked at the time.
Yeah.
He obviously believes that the Attorney General shouldn't have acted the way he did, and he's taken the case to the... You were also Jakpa's lawyer at the time.
Yes.
In fact, you were part of the... At the time, I remember very clearly that you believe it was unethical and possibly a violation of the legal ethics.
Yes.
For Attorney General to do so. You still believe that?
I still believe that. But to be honest with you, and let me put something on record, I have nothing to do with Jakpa's decisions. Even though as his lawyer, I had his full briefing on those interactions. I wrote his witness statement. And I had conversations with Jakpa on that witness statement. We never included in that witness statement anything that he ever did with outside the courtroom with the former Attorney General. I told him point blank, I was focused on the charges and the elements of the charges. And that was it. This thing arose from out of nowhere. I don't want to go into it.
Yeah.
So I didn't influence that outcome. But somehow it came up. And if it comes up, it will be dealt with. I still believe it's unethical. Whether we should pursue it to all of these levels or not, it's another matter.
There's someone said that the General Legal Counsel must take a view of a petition must be brought for...
That is their view. Me, I was Jakpa's lawyer, and I will fight. If we play it back, I'll fight God-fed the same way because I have an ethical responsibility to Japan, and I will do that. At the moment, none of this is in my control. I'm focused on my practice now. It's with the CID and all of that. Maybe whether we should go that route or not is another matter. But
yeah. And the very final one on this case with the Gertrude Torkornoo, because she's not letting go. She's filed another case seeking to stop the consideration appointment of the Chief Justice because she believed the process was so flawed. She was asking for 5 reliefs, quash the proceedings, an outcome of the Palman Committee, quash the committee. You've seen that. Your client, is your client worried that she may...
Don't worry, we have applied to join the proceedings.
You have, okay.
And we will show that. I mean, this is an abuse of the process. Complete abuse of the process. I mean, I don't see how you can say that you've been removed as Chief Justice, but you are a justice. And as I was listening to radio stations, they flattened that argument completely. And if we don't have, at the moment, we have no Chief Justice. Does this country deserve a Chief Justice?
Yes.
So if we do, how are we going to get one if somebody says that that position is a personal one and not an official position from which he can be removed and another person appointed? So I don't see the merits of this case. Unless she insists that she still, and I would have thought that on the back of one of her numerous subsisting cases, should have filed this one as an interlocutory application. Say, because I have a case pending challenging my removal, if you put somebody there, it means I can't come back. But this is a whole suit by itself. But I don't need to comment on it because I want to join.
That's legal advice you just offered her.
I did not know. She's a great lawyer. She's my senior. I can't advise her. And she has
so you've joined seeking
I'm praying to join. I'm praying to join one she's already filed. This one too, we will want to join it.
Okay.
I think that it's just important for the court to have a fuller picture of what she's putting before the court. And for us, the Attorney General wasn't part of the proceedings. Yeah. I was part of it throughout with Danafori. So we will want the court to hear something.
I'm going to take a break. When I return, I'll ask his view broadly about Article 146, not regards to Gertrude Torkornoo, but there's been calls for it to be reformed. And some reform is needed. For example, specifying what constitutes stated misbehavior. Does he agree that we need a constitutional review, constitutional reforms there? And then, broadly speaking, we'll talk about legal education because, by the way, he's also a lecturer. He's also a lecturer, and there are views about reforming legal education. The Attorney General has spelled out some reforms that he's expecting. I'll get his thoughts on that too here on PMX. Stay with me. Thank you for staying with us here on PMX. I'm having a conversation with Tadio Sori, is a lawyer. We've talked about everything, and he's told us a fair bit as far as the law is concerned, but also some of the cases that he's been involved in. Fascinating conversation indeed. He's still my guest. And let's talk about that big subject of Article 146. On the back of this Torkornoo removal, there is a school of thought that says it's time for us to take a second look at it. And at least if you don't do anything at all with it, define clearly what stated misbehavior is. You agree?
No.
Okay.
I don't agree with it at all. It's needless. It's pointless.
But what is stated misbehavior?
It's a whole gamut of things.
But that's my point.
I will
it's
go
subjective
back.
now.
Oh, yes. I like that. Just allow me. It's not subjective. It is very objective. Now, if we go back to the 1969 Constitution, the proposals that the committee made for a draft constitution, there were certain observations they made. That when you talk about the fundamental law of a land, you are not seeking to set out everything in detail. That if you brush your teeth, this is what it amounts to. You must wake up at 6 o'clock in the morning. It must be a compact document that sets out generally what we expect our framework of government to be like. Mm-hmm. Because if you make it too ordinary and regulate every matter, it will look like a very ordinary document and people wouldn't respect it. So points like that are stated generally because the public, which puts all of these government officials in their positions, have a certain mentality or concept that they believe you must live up to. Now, when we say stated misbehavior, or we say incompetent. Remember that the very first constitutional provision of the Constitution on the judiciary says justice emanates from the people. So the people have a particular expectation of you. Can you say that, right in the Constitution, if the Chief Justice gets drunk whilst in office, that's a stated misbehavior? If we find out that she is part of a number of decisions which say that Article 71's office holders are not entitled to have their family members benefit, but yes, she can benefit from it, under the excuse that, oh, her appointment letter, which was written by her appointee or her subordinate, says that she can benefit from it, that amounts to misbehavior. If she decides that she would call the register of a court, can you set all of that out? That's not possible. So that is why you have a committee made up of 3 lay people, because justice is managed from the people, that if your Chief Justice does this particular type of thing, would you still have confidence in her as the person to lead the justice system? And for me, we should make all of those people lay people.
Okay. The committee?
Oh, yes. Because I, as a person who participated in a number of those proceedings, you can see the judges who will work with her beginning to think that, oh, you know, it's one of us. It could have been any of us. But the ordinary person who sits down there says, if the Chief Justice can decide that I will take money that I know I don't have, with the weirdest excuse that it was given to me by somebody who works under me. That is her rule. And I'm not responsible. Hold that person responsible. He is a spending officer, but I am the account holder. But I don't want to hear that I'm the account holder. And it's all okay. What do you think the ordinary man will think? That really? But I cannot come and say that, oh, as an accountant of an institution, oh, I made an accidental slip and added another 0 to a particular thing that shouldn't have happened. So these standards are there to make it fair for us to assess the conduct of the Chief Justice or any justice at any particular point in time by the committee. Remember that the committee makes recommendations. They could say that, oh, under this particular situation, these amounts that were spent for a plane ticket for your husband and your daughter, when they are district courts without standing funds, but their chairs are broken. One plane ticket, what can you do for a district court? When you have written a decision in which you say a president's wife is not entitled to salary because being an Article 71 office holder's wife doesn't make you an Article 71 office holder. Then you can go and say, I am an Article 71 office holder, and my children and husband are entitled to it. How can you...
So you're saying that the committee is clothed with the powers to determine...
Oh, yes.
...what the stated misbehavior is.
Yes, that looking at it, they could have decided, oh, this is forgivable.
So every case you say, the determination must be on a case-by-case basis, leave it to the committee to decide.
Yes, and it's based on standards that must reflect the country's own perception of what they expect.
But shouldn't we document and codify those standards?
And I'm saying it will be limitless. Okay. It would be so limitless. So, for instance, there was a time when I heard Kevin Taylor say a particular justice was sleeping outside their house, and that he would bring it out, he would spill the beans later. Can any group of people imagine that type of situation would arise? And if he had released it and it were true, and a petition were presented for their removal, should the committee not decide whether this is conduct that affects the public image of who a justice is or otherwise? So we all know what is forgivable and what is not forgivable.
But the fundamental proposal you're pitching is that the committee actually should have all laymen and no judge.
Absolutely. Left to me alone. You see, we those involved in the justice system, we judge ordinary men from whom justice emanates. If it affects us, let them also judge us to tell us that, you see, the justice you have been dispensing, that's not what we put people there to do. You're actually doing the wrong thing. You are not serving us. So this whole thing about let's specify, why has it recently come up? I'm saying Charlotte Osei, her crime was that she saved Ghana 15 million Ghana cedis. She came and canceled the contract because she said, look, there was no value for money. Told the contractor, justify why we are paying you this amount. The value that I have assessed is worth this. So 15 million less what you have contracted you for is what we'll pay you. And the contractor took it. In her petition, they said, oh, she should have gone back through procurement. Procurement came and testified that, look, there was no breach of procurement. That in worst case, we can only say best practices may have required her to come back to seek their permission to award it for less than what they had approved. But she was removed. If that is what the society wants, so be it. Okay. And I'm saying at the end of the day, everybody is accountable to the society. What you do is you should account to the society. If they say they don't like your style, you are too gentle, you must insult people like other journalists.
Don't you think there is a risk of abuse of that process, though, because it's case by case and you're leaving a committee to determine?
The worst case scenario.
Because it doesn't have predictability.
It has predictability.
It does?
Absolute predictability.
But for a law to be effective, it must have that. I mean,
so when you now put me in an official position, once I am sitting down there and interjecting and then not allowing people who are watching proceedings in public understand that, oh, at least in a court of law, you should be heard. Somebody who has a case in a Kaswa district court says, I won my judgment. Everything says I should go and execute. I go. And then the public hears that the head of the institution which will ensure justice has said justice should be reversed. The public will tell you they don't like that. And I'm saying at every point in time, look at it is frequency about, oh, our constitution is 30 years old, 40 years old, 50 years old. There are 200-year-old constitutions which have the most atrocious provisions. There's a constitution that of a so-called democracy which has an electoral college, which can make a president win an election not with a majority of votes, but with a minority. And that one is still sitting there, and they haven't complained. There's a country in which citizens can be deported, and it's the stellar example of democracy. We just over such useless things, then we say we want to amend a fledgling constitution like ours. Look, let's test this constitution. When a constitution is very easily amended, it's no longer a fundamental law.
Okay. Finally, on the legal education, the AG recently at a bar conference in your home region laid out a few things that he wants to do with the reforms. One, removal of the sole power of the Ghana School of Law to train lawyers. Two, law faculties will have the power to train lawyers. Duration for legal education will be 1 year. There will be a National Bar Examination Council. You are a lecturer. You support any of this? Where do you stand?
I support it.
Wholeheartedly?
Anything that, and I don't think it diminishes or takes anything away from the law school. The law school could also still train lawyers. But if we are saying that, rather than take or put people from the various universities who come to you and you say they should write an entrance exam and come for an interview and all of that, the students you train, and those universities from which you push them, let them all write one exam. And let there be an overall body to assess which of them is a lawyer.
That's a bar exam, you say?
Yes, the bar exam.
So the entrance exam thing is not there?
Yeah, it's not there. And so let's all go and write the exam.
So the point at which you sift is where you write the bar?
That's all. And if you pass it, you passed.
If you don't pass, you go back and you start again.
And it will take away this whole thinking that a group of people sit down and they decide that, okay, Evans Mensah, let's give it to him. Because you suddenly hear that somebody has been called to the bar. And you are wondering at what point in time that person went through the law school. Because the person has a schedule, which by no miracle, the person could have attended that school regularly. And by the policy of the school, which says you must attend a number of lectures and participate in a particular way, there is no miracle that could have allowed that person to do it. But yet the person, they are calling people to the bar and you see the person there. It will take away all of that. Because at the end of the day, you have to go and write the National Bar exam. So I think that it will allow some transparency.
And they taking the power of having this National Bar examination, so that the General Legal Council, I believe, now has the authority over the schools. they will deprive it of that role, so they'll have nothing to do with the legal
The
education.
General Legal Council has a lot of things to do.
They should focus on that.
They should focus on
and leave the school education.
Perfect.
Okay. Tad, you're sorry.
They say.
When Manchester United plays you again,
We're working.
are you sure?
I can bet you on that one.
But on the evidence of yesterday,
Yesterday, our coach told me,
all you need to do is to say congratulations.
congratulations.
Exactly.
Thank you. Fair play.
Thank you for coming.
Thank you.
Enjoy the rest of your evening.
Thank you very much.